Hello, and warm wishes to all my fellow Americans, wherever you live, whoever you love, and whatever you believe. My name is John Russo, and this is Stranded in Center Field. This week, Americans witnessed the final act in a 30-year-long saga, the irretrievable politicization and destruction of the Supreme Court as a trusted final arbiter of American law. Now, let's not be naive. The Supreme Court has always been influenced by politics. But from the end of the Civil War until the late 20th century, there was a bipartisan understanding that America's High Court should, at least in principle, aspire to apply the law to the issues of the day and should not substitute its policy and political preferences for those of the elected representatives in Congress and in the state legislatures. As a result of this common understanding, both parties were expected to, and did, accept the interpretations of the Supreme Court as final. A prime example, Al Gore in 2000. Now, in the opinion of most constitutional experts, Gore had plenty of good reason to disagree with the Supreme Court's decision in Bush versus Gore. Nevertheless, he went on national television to accept the Supreme Court's decision and to urge the country to move on and support the new administration. Does anyone believe that in the same circumstances today, we would get a candidate going on television saying, I'm okay with a Supreme Court decision that I don't like? Now, Bush versus Gore was the warning bell about the future of the Supreme Court. For those of you too young to know what happened, or for those who have forgotten or tried to forget what happened, the facts of the case are as follows. There was a recount moving forward in Florida because the presidential election between George Bush and Al Gore was too close to call. The Florida Secretary of State, who was responsible for supervising the election, certified the results for George W. Bush while the vote count was still being disputed and before the ongoing recount was completed. She was also the Florida state co-chair for the Bush for President campaign. So, of course, Vice President Gore challenged her decision and went all the way up the Florida courts to the Florida Supreme Court, where, based upon Florida state law, Gore won a decision, not that he had won the election, but a decision to order state and county officials to complete the recount and count all the votes. At that point, the Bush campaign requested that the Supreme Court step in, and it did. By a 5-4 majority, the High Court voted to order a stop to the recount. Now, this decision violated not one, but multiple rules of judicial interpretation. First, it overturned a decision of a state Supreme Court on an issue of state law. Two, it claimed Supreme Court jurisdiction over an area that the Constitution specifically granted to the Congress. And third, it rendered a decision based upon a critical issue of constitutional law without a full presentation and briefing on the issues. I want to note for you, the Supreme Court issued its written decision in Bush versus Gore in less than 24 hours after oral arguments were heard. Now, it's not just that the decision was widely criticized by constitutional attorneys on both sides of the partisan divide. In a passage of the opinion that can only be described as the judicial equivalent of shameful blushing, the court majority said that the Bush v. Gore decision should have no precedential value. Let that sink in. One of the most important decisions of law made by the Supreme Court in our lifetimes was disowned at its birth by its parents as a decision that was not based upon law that could be relied upon for future legal guidance. One would have to be pretty gullible to believe that this decision was founded in law and not in political activism. And let me tell you why. First of all, on election night, when early returns suggested that Al Gore would win the election, Justice Sandra Day O'Connor made it clear to several witnesses that she thought Gore's election was a disaster. This is an undisputed fact. A real judge, O'Connor, several years later, she expressed regrets about the Bush versus Gore decision and wondered whether they had done the right thing. Second, Clarence Thomas, a man who was a full-throated, hard-right partisan operative during the Reagan and George Bush Sr. administrations, and was nominated to the Supreme Court after barely a year of judicial experience, had a very personal conflict of interest. His wife, Ginny, had a very high position in the Bush campaign. While her husband was hearing arguments at the Supreme Court and voting to stop the recount and declare Bush president-elect, she was working on the Bush transition team to draw up a list of potential appointees for the new administration to consider. Last, Nino Scalia. Now, Scalia is the most activist Supreme Court justice since Earl Warren, an advocate, a partisan, who posed as a judge who covered his tracks by lecturing against the evils of judicial activism. Scalia had a conflict of interest too. His son worked for the law firm that had been appointed by the Bush campaign to argue the Bush case before the Supreme Court. Of interest historically and in the moment is that the majority decision was written by Justice Anthony Kennedy. Now, Anthony Kennedy was unanimously confirmed during the last year of the Reagan administration, with an election coming up, by a Senate in which Democrats held a majority. Kennedy was nominated by President Reagan within 1 year of the 1988 election. And you can understand why it's especially galling now to Democrats when Mitch McConnell says that no party holding a Senate majority has ever confirmed a Supreme Court nominee of a president from the other party in the last year of a presidential term. He is misleading the American public. And I believe that Mitch McConnell, more than anyone else, will be remembered in history as the man who plunged the dagger into the heart of the Supreme Court's authority. And the beat goes on. Brett Kavanaugh, like Clarence Thomas, is a partisan through and through. Not only did he make his name in GOP circles as one of the lead investigators on the Starr Report, which was the basis for the impeachment of Bill Clinton, but 2 years later, he turned up in Florida, where he was very publicly involved as part of the Florida legal team that represented George W. Bush in the Florida courts during the 2000 presidential election. I don't know whether the allegations against Brett Kavanaugh regarding sexual abuse were true. Maybe they were, maybe they weren't. But even if they were false, his disrespectful and inappropriately defiant and partisan demeanor at his confirmation hearings demonstrated conclusively that he does not have a judicial temperament. And it shows again that the Republicans are nominating judges onto the Supreme Court who are not really judges so much as policy advocates. The obvious hypocrisy of Mitch McConnell's statements about waiting for the will of the people 8 months before the 2016 election and his rush to confirm the Barrett nomination today, while an election is actually in process, proves one thing: power and short-term gain has come to matter more in modern American politics than the institutional stability of the American Republic. McConnell argued that the Constitution did not require the Senate to even hold hearings for President Obama's last nomination, and an experienced and moderate judge, Merrick Garland, did not get a hearing. That was court packing. The GOP changed the customary rules regarding how many votes were required to confirm a Supreme Court justice to accommodate their slim Senate majority. They argued that the Senate rules were not in the Constitution. That was court packing. Republican legislatures in both Arizona and Georgia have within the past several years added justices to the state Supreme Courts in their states. That was court packing. And now, in a political variation of the psychological concept of projection and facing a possible electoral rout next month, which could result in a Democratic Senate and a Democratic president, what is the GOP complaining about? Court packing. They're claiming that the Democrats will pack the courts. Now, ideally, the Democrats shouldn't. But I think given the history of the past 20 years, it's a little much to ask that the Democrats now not do what they are constitutionally permitted to do when the Republicans have unceremoniously disposed of traditional norms as if they were drunk teenagers throwing fast food wrappers out of a speeding car. The consequences of this McConnell-directed saga, this GOP-directed saga of institutional vandalism will be with us for the rest of the 21st century, and I fear could result in the end of government by law and not force. When that happens, there will be plenty of blame to go around with both parties, but make no mistake, those who claim to be conservatives were actually the radicals here. And history will note with delicious and sardonic irony that those who cloaked themselves in the mantle of law and order were in the forefront of the annihilation of the rule of law. Thanks for watching. That's it for this week. Please leave your civil comments and suggestions below. This is John Russo saying, I'm not stranded, and neither are you. There are millions of us Americans standing together here in center field. Until next time.